facing you. What we want to do in the next hour is basically talk about, let me get here quick. Sorry, I got to go back to this one. We want to talk about some of the compliance-related issues that we're thinking about and we're hearing from you. So what regulations from a compliance standpoint come into play with some of the situations you might be facing? And then what resources do you have and that we can provide for you? That's what we want to talk about. So the first one is there in Roman numeral 1, there's lots of regulatory guidance coming out. We've had 4 different bulletins come out. We are going to reference some of those things when we get to talking about reporting delinquencies, things like that. But they're short. Most of them are 2 pages, 3 pages. Take a look at those. If you haven't seen those, make sure that you're aware of those things, that you have that. So far, this is what we have. I think there's going to be a lot more to come. But I'm going to tell you, probably the number one burning question is coming up with this whole modifications. Roman numeral 2, I'm going to move to right now. The modifications, renewals, refinances. How do we do it? What can we do? So let me just take us back a little bit and explain a couple terms. First off, what is a refinance? By definition, under Truth in Lending, RESPA, HMDA, it's when you satisfy and replace. So imagine you have loan A, it is gone, it's released, it's extinguished. The regs use the term satisfy, replace, extinguish with loan B. So A doesn't exist anymore contractually, B took it out. Now, shortcut this a little bit. If you refinance, you have to give all new disclosures. You're starting from scratch. Okay. Sometimes we hear lenders use the word renewal. I'm going to tell you, in a sense, it really isn't a regulatory term. You might see it in flood, but flood isn't written by our regulators. It's written by FEMA. So what's a renewal? And I'm going to tell you, it's either a refinance or it's not. And it's based on contract law. So that's just a banking term. Let's not use that here today. Let's go to modifications. Maybe you call them extensions, increases. Maybe this is your renewal. But here, we're not contractually replacing, we're adding something to it. So in my illustration of A being replaced by B on a refinance, in this case, it's A gets something added to it. It becomes an A plus, if you will, okay? So another piece of the pie. So figuratively, I could do it this way. If this is loan A, I simply type up something and I attach it to it. So A still exists, but we're doing something to tweak it, to modify it, extend it. Now, you can have all sorts of terminology, a launch, and different things like that, but it's one of these 2 camps. It's either a refinance or it's not a refinance. It's an extension or a renewal or a modification. Now, there's an article after the end of your outline, and that article is called, I have it here somewhere in all of my other things. Darn, you guys probably have it. Yes? I found it. Sorry. Right after page 7, you'll see an article called Banking on BCC. That's our magazine. It's modifications, renewals, and refinances. A bunch of details in there for you to read through, but it just told you what I said here. Plus, there's a couple limitations. You can't go from fixed to variable without refinancing. You got to give all new disclosures. You can't go from closed end to open end credit. Okay, so I can't have a loan that I turn into a line. If you do that, you need to start over and give all the disclosures. But if somebody comes in and says, hey, I lost my job, or I'm not getting the income I normally had, I can't make this month's payment, or I see something down the road where I'm not going to be able to do, what can you do? You can skip a payment. You can add collateral. You can take away collateral. You can add more money. You can extend the loan. You can take that payment out and put it. You can do all sorts of things in a modification, and you don't have to give any new disclosures. Now, that's the simple part in the sense of what's a modification, refinancing, so on. The next step in is, what if you're doing, well, flood insurance might come into play because possibly this is secured by improved real estate. We're going to come to flood. I'll come to that one later. What about escrows? What if they skip a payment and we don't have an escrow, and we have an escrow on there? What are we going to do about that? And the answer is, you got a couple options. One is you could just let them skip it and they're going to be short. But if that's going to be multiple months, you may not want to do that. Could they just pay the escrow? Could they pay the escrow and the interest and let the principal keep going? I mean, those are things that you have to think about. You do get a 2 months cushion if you've automatically, or if you've appropriately set up your accounts with 2 months cushion, that they have a month or two is not going to leave you in a deficient standpoint. You certainly don't want the collateral to go uninsured. You don't want the collateral to not have its taxes paid. So that escrow issue is something that's going to be difficult. Could you advance more money so that you can take that towards the escrow? That's another possibility. Now, before I want to wrap this up, I want to make sure that you also understand when it comes to HMDA that modifications are not reportable. Refinances are. But if you're doing modifications, we really don't need to worry about truth in lending, RESPA, or HMDA. And you can see there we quoted some Romanettes for you and tried to give you this article that you can read more. So, Jared, Kevin, I'm going to invite you guys in there in a sense. Is there anything? I mean, there's a lot of opinions here about what to do with the escrows and things. Do you have anything you want to add to those?
Well, I think I'll chime in here. I think it's important to look at the escrow side of it. Is the regulation doesn't give us anything to really go on. So it's not like if you do this or that, it's necessarily a violation, but there's consequences. So you've got to make sure that you're preparing management, those people that are responsible for handling your escrows, for what's going to happen if we do this or if we do that. And I'm not saying you even need to be consistent with all of your customers. Some customers might be able to handle keeping the escrow going, so taxes and insurance get paid. Some might not have the wherewithal to do that. I mean, every customer has different facts and circumstances right now, and we need to be prepared for a lot of different ways, a lot of different avenues to go down.
Well, and a lot of banks have different processes for how they manage their escrow, and if you have it being done manually by a certain person, and you get a flood of these types of requests, particularly now, you might want to make sure before you go one way or the other that this poor person who's going to be doing all the work is ready for it. So
yeah. And let me do this. We're not here to try to sell you anything. We want to point you towards resources. But I just thought, Kevin, when you mentioned that, I thought about short year statements that might come into play. Right. That maybe we're not going to be able to do escrow payments as normal right now, but 3 months from now they get their feedback on they get their feedback, they get their job back or whatever. There's also this economic stimulus package that was just passed. Maybe they get their $1,200 check or $1,500 check, or whatever it's going to be. And then we can reanalyze. But you're right, that's going to be a burden maybe on those. We have a whole 2-hour webinar on how to do escrows that we can't get into the weeds on that today. And that's like a lot of these things. But we want to think about it. Or maybe you say, I already understand all that. Great. But I didn't think about this, but we got it. We want to make awareness, and we want to give you resources if you need them. So
I think you hit on something important there, Dave. The word awareness. Some of the stuff we're not going to have, and you're not going to find answers to today, not even maybe tomorrow, but you have an awareness there's going to be something out there on the horizon. Like you mentioned shortage. Yeah, if they don't pay their escrow, something's going to happen, and there's going to be something we're going to have to deal with down the road. We need to make sure that we're prepared for that down the road when that hurdle presents itself.
Yeah, good point. So I do think knowing and understanding short year statements and how you can reset your escrow account computation year is going to be really beneficial thing, a tool for your arsenal of attacking this problem that you have. So this challenge. So, all right. Well, let me move on to Roman numeral 3. So I put up a picture there of a dunking the ball. The idea is you might have a customer that comes in that needs the money right now. Well, right of rescission has a waiting period. TRID has a waiting period. If it's a high-cost mortgage loan, there's a waiting period. 3 different sections of the regs. And if you'll look in Roman numeral 3A, we talk about right of rescission. But if you go down to B, we basically say, here's those other sections. They all have the exact same wording. That says if there's a personal financial or bona fide financial emergency, that you can waive these. Now, here's the trick. A2. The customer needs to give you don't give them, they give you a written statement. Now, it doesn't say it has to be in handwriting. I'm going to highly recommend it be in handwriting, because if you think about this, how many times have you ever waived any of these things? And I'm going to bet most of you have none, maybe 1 or 2 kind of things. So I highly recommend you say to the customer, here's a notepad, write this down. I wish to waive my right of rescission, and here's why. Then you have to do that. Look at the bold print in Roman numeral 3B. One statement doesn't satisfy all 3. They're going to have to waive their right of rescission. They're going to have to waive their TRID waiting. They're going to have to waive their high-cost mortgage loan delay. So 3 different statements. All borrowers that have those rights have to sign those. So you can't have a form letter. And again, it's such a sensitive area. I recommend that they handwrite it out. And I know that the people are going to say, why would I want to do that? And, if they want to do it, why do I have to do this 3 times? It's regulations. And I'm sorry, but we need you to do it this way. You'll find additional guidance in the sense in that in those Romanettes that we talked about. But what's a personal bona fide financial emergency is really in the eye of the beholder. You get to decide what that is. I'm not saying that this crisis is a financial emergency for somebody, but it could be. Maybe you'll have a circumstance. So we want to let you know about that this is something you want to be ready for, and make sure that all of your loan officers understand it can be waived, but here are the rules. Now, I know it's 3 months away. We don't have in our library right now a webinar, but in June 23rd, we are going to be covering that. Like everything that we're going to talk about today. If you have any questions we want you to ask today, if you have questions tomorrow, next week, next month, give us a call, email us. We will guide you through these things. So,
hey, before we go on from this one, I just want to draw attention to one thing that I even got to thinking more about it as I was listening to you talk, Dave. In letter B, where it says in the second line, TRID's waiting periods, remember there's multiple waiting periods in TRID. There's a waiting period on the loan estimate side of 7 days after the disclosure, the loan estimate is dropped in the mail or delivered before you can close. And then there's another one with the closing disclosure. Each one of them, as it states in the bold print there, will have to be independently waived, as well as the other ones that Dave did mention. So keep in mind, TRID can be a little tricky that way, that there's multiple waiting periods.
So let's do this. I want to slam dunk this loan, Jared. I need my money tomorrow. I don't have time for this. And it's a rescindable loan, okay? So I'm using my house as equity. We got a TRID. It's a high cost. You're telling me I got a loan estimate, waive that. It's a high cost mortgage, waive that. TRID closing disclosure, waive that. Right of rescission, either open or closed, doesn't matter. There's the same rules, waive that. Could be 4 of these. You're right.
Yeah.
So
no pre-printed forms in there. Well, you justify the decision.
All right. So put on your regulatory hat here just a minute. I'm going to write it out once. I wish to waive all waiting periods for right of rescission, TRID, high cost mortgage, closing disclosure, loan estimate, signed Dave and my wife. What do you say?
I think I'd let that pass, and I would hope that this time that we're in would be nice to us and let that work. But if you want the path of least resistance, you'd probably do it 4 times.
Well, from a regulatory standpoint, technicality, it says this one requires this. What's one? But my gosh, to think that's a burden to the customer too, right?
Yeah.
Yeah.
Kevin, give me a yes or no, thumbs up or thumbs down.
I would say it'd be one of those violations if they come in and say you only have one form here. I'd probably just give them the old "come on, man," and
I'd tilt my head a little bit to the side. And, yeah. Okay.
Yeah.
How about this? I wish to waive blank, signed dated. Here's why. Go photocopy it, fill in right of rescission, fill in loan estimate, fill in. Maybe that's the answer.
I might encourage the question where they're saying, okay, now how did that communication go? Were you leading them down the path of waiving their rights? Or
absolutely, that is going to be the thing. Right. Yeah. Right. So, but the customer fills out and leaves it blank, and then they fill in right of rescission, fill in loan estimate delay, fill in closing disclosure delay, fill in high cost mortgage loan delay. Could do that. They write it out once, and then you fill in. Anyway. Yeah. If an examiner gets in my face about this one, I might punch him. I don't know. Anyway, sorry, I'm not encouraging that. Let's go on to Jared. Take us to TRID.
Well, let's do a little bit of TRID. I wish we could take the next hour or two to deal with all this stuff.
And I'm going to interrupt you here. I see a lot of people, I think, they're asking questions in our chat function. Do us a favor, put it in the Q&A button. There's a different room that is being monitored by Diane Dean, who's going to be presenting the questions. So if you've asked a question and you put it in the chat function, put it in the Q&A button again, please. Thank you.
So from a TRID standpoint, there's really a lot here that we could talk about, and I'm going to do kind of the opposite here. If you look at the bottom of the page, number 3, we're doing 2 hours on this in the weeds, but let me do something so we can help out with the awareness. So it's game on as it relates to change circumstances. Many of the bankers that we're talking to, they're seeing change circumstances being brought forward like they've never been before. You probably encounter them here and there in your normal, what used to be normal stream of mortgage lending. I tell you what about this? What about that? And just stuff that we've never even thought of before. So we want to bring back the awareness here. Page number 3. Underneath letter A, I've got the general change circumstance events. We've obviously are living through right now what is this extraordinary event that obviously is going to cause some things to change. What you thought was going to be the closing date, what you thought was going to be the way it was going to happen, it's all up in the air. Now, some transactions will go forth and be fine, but others, you're going to hear things you aren't used to hearing about. And in most cases, they're going to fit within one of these loopholes that are within TRID and the changed circumstance environment. Inaccurate information. What was deemed to be accurate last week might not be accurate this week, might not be accurate before closing. You're going to have people bringing new information to you. My paycheck went from this to this, or I don't have a paycheck anymore, which brings us to applicant eligibility. I mean, all of these are on the table. And again, you're going to hear things that you haven't heard before, but that doesn't mean that they're not legitimate. Here's what it's going to come down to. You've got to make sure that you meet the timing requirements. When you do encounter a legitimate change circumstance that you can put in one of these buckets, within 3 days of that change circumstance, as it relates to something that affects a fee that's tolerance related, like the 0% items or the 10% tolerance bucket, you've got to redisclose and get that new disclosure out the door. Now, you got to do that all in keeping in line with the TRID 2.0 requirements, which require everything on that piece of paper to be accurate. And then there's a whole slew of things that come with that we just don't have time to get into today, but there's a lot of red tape that you've got to make sure that you take care of. Now, that's just the timing side of it. You also need to document each revised disclosure beyond the first. So we're talking about the loan estimate to start with here. But you certainly could have closing disclosure revisions. Those are a game. But let's just talk about the loan estimate for a minute. You've got to document why each one exists beyond the initial version of it. You've got to tell that story. And without that story, auditors or examiners aren't going to be able to pick up on what's going on. And there's a little thing in TRID that says that documentation is required by the regulation, which means you get cited if you don't tell the story and leave it to someone to assume or imagine what's going on. So make sure you meet the timing requirements, the documentation requirements as it relates to these TRID change circumstances, which again can happen on both the loan estimate side and the closing disclosure side. Speaking of the closing disclosure, you'll notice I put letter B in there, the closing disclosure accuracy. This is something that until we had this event go on that we're living right now, probably a lot of people weren't aware of and didn't pay attention to. But on the closing disclosure side of things, there's a good faith standard that has to be met there, just like there does on the loan estimate side. You've probably all heard it before. We've got to put these disclosures out, and they've got to be the best information reasonably available. And the lender's got to do this thing called due diligence to make sure they're as accurate as they can be. And you've probably had that education. You've probably heard that on the loan estimate side. But the same holds true for the closing disclosure. And maybe you even know that much, but let me give you the piece that maybe most don't know about. And it's absolutely relevant with what we're living right now. If you look at letter B2, actual terms unknown, what TRID says is when you're getting ready to put the closing disclosure together, you're supposed to base it on the best information available to obtain accurate information. And you're supposed to perform this thing called due diligence, the same thing we've been talking about for the closing disclosure. And I know all you're going, well, yeah, duh, we do that. We make sure we get the actual numbers. Are you having troubles getting actual numbers in this time that we're living in right now? And I'm hearing from a lot of you is, yeah, some of these businesses aren't open. Realtors aren't communicating. Attorneys aren't communicating. And we're struggling to get these numbers from what we call third parties so we can represent the information accurately on closing disclosures. What TRID says is that the bank has to make an effort to reach out and get the information from these third parties. And that's that due diligence expectation. And there's wording in the regulation that addresses that. But it also goes on to state, essentially, that the creditor, the lender, does not have to hold up closing because I can't get a closing disclosure out a week ahead of closing so it lands in the borrower's hand 3 days before closing. What the regulation says is, bank, you need to make an attempt to get information from third parties. In the event that you don't, you can base the closing disclosure, the initial version of it, on the best information you have at hand, which means in some cases you may be, and I don't want to use the word guess, but if the realtor won't get you real estate commissions, you might look at the sale price and go, you know what? It's usually 3%, and for the borrower and the borrowers and the seller's agent. And so we're just going to go with that so that we get the closing disclosure out the door today on Wednesday so we can close next Wednesday. And then the rule goes on to state you'll have to provide an updated version of it when you get the accurate information. So not being able to get information from third parties shouldn't hold you up in getting closing disclosures out on a certain date so you can close a week later, assuming you're all mailing them out. And I know we do in a lot of cases. So that's an area you might need to study up on. And if you want more information, we have it. We'll be doing it in that webinar that you see at the bottom of the page. But there's certainly a lot of awareness that you aren't used to that you may need to become accustomed to as it relates to TRID and the requirements in that space. Let's go to page 4. We're going to change gears here and go to Roman numeral 5. And this is one I don't think a lot of people were thinking about, at least not until I think it was yesterday or the day before, but it's ability to repay in qualified mortgages. Now, I bring up yesterday, the day before, I'm not sure which it was, but the Federal Housing Authority put out some information about verification of employment. Now, let me back up a minute. The ability to repay rules, there's a whole lot of red tape and boxes that have to be checked in order to comply with ability to repay, and then in some situations, qualified mortgages, whether they're the government-backed version or the small creditor version. Now, if some of you are lost, not sure what we're talking about, we've included one of our free resources from our website. It's on the screen. It's also at the back of your materials. It's page number 14. But that represents, in a nutshell, what is the ability to repay in qualified mortgage requirements. Let me boil it down to this. Letter A, the rule has not been relaxed, and I don't anticipate it being relaxed. If you make a new loan, meaning you fund money or you refinance money, you're going to have to deal with ability to repay and potentially qualified mortgage status, which means you have to check all the boxes. You have to make a reasonable determination that somebody has the ability to repay the loan based on verified information at consummation. There's no relaxing that we're anticipating here. Now, some of you may be misunderstanding that information that was put out by the Federal Housing Authority. All they did was relaxed an interpretation. The regulation says you have to base this decision, ability to repay, on verified information, one of which is a verification of income. Well, a verification of employment. Well, that's one of the verifications that you're allowed to do verbally. You could pick up the phone and you could call Bankers Compliance Consulting and get Dave on the phone, and hopefully he'll tell you that Jared still has a job. But if he's not picking up the phone because his office is closed for some reason, because he's in lockdown or quarantine or whatever it is, you can still do ability to repay. You just might not have the same feel good about the documentation. Because what that guidance that came out from the Federal Housing Authority said is that you can rely on a bank statement or a pay stub. Well, you've never not been able to rely on those. There just aren't real great practices, because just because somebody has a pay stub, just because somebody has a bank statement that shows a deposit, doesn't mean they have a job. In fact, there's a lot of people that, unfortunately, because of what we're living, have lost their jobs or they've been laid off. They might get a pay stub for the next week or two or month or whatever. Doesn't mean they have employment. So be careful, proceed with caution in that area. The last thing I want to mention here is the modifications. Dave talked about them earlier. They're absolutely important. In fact, when they wrote the ability to repay rules, they kept the loophole open for just not this instance, but instances that could be related to things like what we're living today. There are borrowers where you've made loans in the past and they're going to approach maturity, today, tomorrow, next week, next month, and their situation isn't going to be what it was when you made that loan. And if you tried to put them through the hoops that are ability to repay, you know what? They're not going to pass. And it's not a risk you're necessarily willing to take on in the event that you have to go to court someday and defend why you made that loan. But you know what? You don't want to start foreclosure, because for some reason they still are paying you. Even though they can't pass the test, you get paid, or you're doing a workout. And so if you're approaching maturity, you can modify those loans exactly the way Dave talked about earlier and avoid the ability to repay game. And that's a legal circumvention that they purposely left open as it relates to these requirements. It's another one. We're going to get into a lot more details than what we can during today's program if you look at some of the resources there, but we'd love to give you more information if that's something you're seeking out.
We do need to talk about your job tomorrow, by the way, when we're done with this session, Jared, but let's go on for now. Anyway, you want to go ahead and with mortgage services?
It's still me. All right, I thought I was out.
maybe you're grasping for air right now, but
shoot. I'm good. Let's go to page 4.
That or Kevin, you need to have you take over.
Right. This is real. No. Number 6, mortgage servicing. I tell you what, I really struggled in, all right, how am I going to bring this awareness to you and not necessarily leave you hanging, because there is so much going on here. So I did, and I know you're maybe getting sick of the word, I just wrote the word awareness next to the mortgage servicing here, because that's what this is going to be about. We list out 4 things here relative to the servicing rules that we think are going to be impacted or intersected with this coronavirus thing that we're dealing with. So the first one, information requests. Here's what I want to leave this one at. Whether you're a large or small servicer, and yes, there's a difference for some of these things as we talk through it, but for this one, there's not. Whether you're large or small, if people come looking for information about the servicing of their mortgage loan, hey, first off, if they don't put it in writing, you're just going to default to plain old everyday customer service. Do unto others as you would have them do unto you. But if we're talking about a request for information that they put in writing and they meet all the stipulations within the regulation, then you have a lot of red tape that you have to follow in supplying that information. Okay? You have to respond within a certain number of days. And if you're not going to provide information, you have to respond certain ways. So there's a lot of red tape there that you simply need to be aware of if they put it in writing. Now, the next 2, really 3 go together. These 3 rules were written to help borrowers who have loans that are secured by their primary residence, yet are struggling to make payments, stay in their homes. And the expectation is that you will be doing as much as you can to enable that, to help the borrower who's struggling to make their payments keep and stay in their home. So the first one is early intervention, and it works like this. Okay? And I better do this too. Letter B and C, they're only required for large servicers. However, if you're a small servicer, I do think this is a best practice guidance that you should be not straying too far from. In fact, some of it you have to do anyway, and some of it you just do anyway, I guarantee it. For example, letter B, the early intervention, the expectation there is that before the 36th day of someone being past due, you attempt to make live contact with them so you can discuss the options that may be available to them in the event that they're struggling to pay. Absolutely something that's impacted with the events that are going on in our industry today. Before day 45 past due, you have to send them a written notice. And then you do that once every 180 days. So let's think about large servicers have to do that. Small servicers that are listening, I bet you work your past due list before they get to day 36. I bet you're sending out a 45-day past due notice with counseling information on it because you're required to do that. So even though you're not required under the servicing rules, there's other reasons you're probably doing the same thing. The continuity of contact, letter C. This one ensures that when somebody who's struggling to make payments, which you've likely heard from some of those people already, and hopefully before they've struggled to make their payments, they're going, hey, I've lost my job, what we can do. Hopefully you've got those calls and you're helping those people out. But what letter C says is when they do call you, that they don't get passed around like a baton. If I'm the struggling borrower and I pick up and say, hey, lost my job, it's, I'm one of many, what can we do here? I've got a payment due in 15 days. What can we do? What this says is when they take and pick up the phone and call you, they don't get passed around like a baton. And I'm sure you've all lived through something like that where you picked up the phone and they passed you along like a baton and you eventually just hung up because you weren't getting anywhere. They don't want struggling borrowers to not get anywhere. So what continuity of contact says is when they pick up the phone and call you, you get them to someone or a department that can help today, and they don't get passed around like a baton. Letter D, and again, that's large servicers, but small servicers, you're probably doing the same thing. That would be the expectation. Letter D gets into loss mitigation, and there is so much there. The majority of it is only large servicers, yet there's one thing that everybody listing has to play by this rule. You cannot start foreclosure until the loan is more than 120 days past due, or you're joining somebody who's already started foreclosure, or somebody is, and off the top of my head, I don't remember, but there's a couple of different things in addition to being more than 120 days past due that you've got to make sure that you take into account. That's everybody listening. The large servicers, there is a ton of red tape. You have to define what a loss mitigation application is. And you're going, what does he mean by loss mitigation? Workout agreements, modifications, as Dave mentioned. Troubled debt is how some of the documentation has come out with the guidance. If you go back to page 1, you have to define what these workout agreement applications are. And remember your Reg B requirements. It's all going to fall under there. Applications start in that regulation and nothing changes there. If you turn somebody down, you owe them adverse action notices. And there's a lot of other timing elements that are tied to these loss mitigation requests. Now, I'm going to leave you with this because there's so much more here. And if you're hungry, we've got the solution. Bottom of page number 4, you'll see we reference a mortgage servicing webinar, and you'll note that it's from August of 19. Let me do this. Nothing's changed in this world as far as regulations go since that August 1st, 2019 date. So if this is something you need more on, that's still a relevant webinar that's 100% accurate. And we just want to be there to help you out.
Oh, you're muted, Dave. Yep. While he's coming in, Jared, I just point out on the servicing rules, if you remember, all of those rules came about because of the last financial crisis that hit, and we didn't do customer service right as an industry. So if you don't want more on your plate in the future, let's handle this one right and make sure you're talking to your folks about customer service.
Great point.
All right, I'm a little confused. Are you hearing and seeing me or not?
Yep.
You're all good?
Yep.
Huh. Okay. I'm not sure what happened there. I thought I was fine, but here we are. Let's go to page 5. Let's talk about flood insurance. I talked about earlier that if you refinance, increase, extend, those kind of things, how truth in lending, HMDA, all RESPA all play in. Flood's a little different. Now, first off, we'd have to have improved real estate. But if you're going to add real estate to a loan, if you're going to extend the maturity date, touch it contractually, if you're going to increase the loan amount, maybe because they can't make their loan payments and you say that escrow situation will advance you a little more, then you're going to have some potential increases in extension. So MIRE, make, increase, renew, extend, that's the flood insurance rules. I want to really emphasize that increase dollar amount, extend maturity date. Then you trigger all of the flood rules again. So make sure you understand flood determination. Now, you might be able to rely upon a previous determination. Maybe not. You're going to have to give them a new notice if they're in a special flood hazard area. You're going to make sure that you've got the right amount of insurance. Basically, it's all the rules start over again. Letter B, someone brought this up to us, one of our clients, about they can't afford to pay their flood insurance because they lost their job or they're reduced or whatever. There are no exceptions, and you're going to need to force place flood insurance. That's the notification, etc. We don't have to, kind of like the loss mitigation, all those things. We don't have time to get into the weeds and all these. I want to give you awareness. Don't waive this. Okay, you have to require flood insurance. We don't need a bad situation to go that to worse that they have a flood. So there's requirements that you're still going to have to do. Now, again, if they can't afford it, we got a whole other problem, right? But you have to follow that rule. There's no exceptions. That's our point. If you need more information about flood insurance, Jared and I teach a 4-hour, it's two 2-hour webinars. We just did it in March of last year. That you could get into the weeds and all that there. So, Jared, I'm going to go back to you. We're talking about, making changes, and this loan officer's over here doing this, and this loan officer's over there doing that, and that invites risk. Talk about fair lending.
Normally I'm a heavy stickler to fair lending, and I want to be careful with this one. So we're not going to waive anything when it comes to fair lending, but I'm hoping, and I know that people aren't just going to go and only make changes for certain populations, certain people's. That's not happening. Let's just go into it assuming that. So let's go to what's on this page. Consistency and documentation are 2 rules of thumb when it comes to fair lending. Now, I know from talking to several of you and listening to what you're saying, what's happening on the front line is that these things are coming fast and furious. These phone calls from borrowers that are having these changed circumstances, and they're not going to be able to make their next payment. So what do? We don't want to have a free-for-all. But you're going to have different facts and circumstances for each situation. We need to just make certain we tell the story. You're going to have borrowers that, because you have some of you multiple lenders in multiple locations, that are just a little bit different with how customer A was handled than customer B. As long as we write the story and we're able to break down that it had nothing to do with the protected class, you're going to be just fine. There's got to be some logic and common sense that gets put into this. Now, no documentation and a complete free-for-all will get you in trouble and people to ask questions. So make sure you do the right things here and dot the I's and cross the T's.
Great. Kevin, before you start, I just want to remind everybody, if you have questions, we're going to try to get done here in about 10 more minutes, and we're going to try to take some of your questions. I see there's a lot already in the queue, but go to the Q&A button on our Zoom platform. I see that some people are typing them into the chat function. That's watched by our administrative people. We need you to put them in the Q&A room, the button. That's a room that Diane Dean one of our consultants. She's watching that. She's grouping like questions. So, Kevin, not only is this lending oriented, let's go over to Bank Secrecy Act. There's some things that come into play.
Secrecy Act hasn't gone away at all. In fact, fortunately, FinCEN has given us a little bit of guidance. If you're in the BSA side of the bank, you've probably already seen March 16th. They send out a very short bit of guidance related to the pandemic. Now, the first thing that it referenced was you may have some operational problems, and the people who are filing your reports and gathering the information, you may have disruptions in that chain. So if you're concerned about being able to meet all of the filing timelines, it encourages you to reach out to your regulator and FinCEN, because those types of things, can happen. So that was the first bit of guidance. The other part of the guidance said, really just told the industry, don't let your guard down. We know that there's a lot going on in the world right now. There's going to be a major change in the types of transactions you're seeing. There's going to be a lot of different types of loans that are coming up, changes in operation. But don't let your guard down. There's a number of scams that they've identified that are related specifically to the pandemic. Apparently bad guys, they're just waiting for the next crisis to take advantage of. So they pointed out this list, and I would take a look at it at your bank. Things like imposter scams, where these bad actors are coming out and pretending to be the CDC or the World Health Organization or some hospital and trying to get donations or personal information or things along those lines. Investment scams, where they're going out and getting people, as the stock market is crashing, they're getting people to reinvest in companies and lying about what's actually going on. Product scams, there's shortages all over, people going out and selling face masks and toilet papers and different things, and then insider trading as well. So there was a list of things that they recommend that not only the monitoring folks be aware of, your frontline staff should be aware of it as well, so that they know what to look for and maybe to ask those questions. If somebody's coming in and pulling out all of their money, it might be worth asking a question, or even better yet, letting them know, look, there's all these scams out here. If you're looking about investing, or if you are buying things, be aware of these scams. Protect your people, because scared people make bad decisions. And then also, if you do come across one of these, they recommend that in your SAR filing that you put COVID-19 in field 2 of the SAR. That's COVID-19 in field 2, and that way they can quickly track these types of scams that are out there. One final note, I would just recommend update your risk assessment. Your risk assessment from a BSA perspective is to be, monitoring current threats and future risks. This is the best time. And actually, you kind of have a little bit of a cheat sheet here to get started. Imposter scams, investment scams, product scams, insider trading. Those are risks that are associated with this time that we're in right now. So.
Very sad, isn't it? I got a phishing attempt this morning about the stimulus package, and you're needing help, and yeah.
Oh, and they're going to small businesses they're reaching out to, and trying to get them to do things that they would never otherwise do. So the best way we can help our customers is to help them be aware.
Right.
Oh, we lost you again, Dave. Nope. No.
All right.
Oh, now you're back. Oh, now you're.
I'm not sure what's going on here, but you're seeing me?
I'm seeing you, but you're really quiet.
Okay. You guys, if you can't hear me, you want to take it? You got it.
All right.
We can hear you there. You might just have to talk loud.
Yep.
Okay, let me talk loud. I'm not sure what's going on. All right. Reg CC has a rule that I've never really looked into. In fact, I put some things in your outline, and then I realized there's an error. If you have some emergency conditions, typically I think this is written for a flood, tornado, something like that wipes out. But maybe because personnel are sick or staying at home or whatever, can't get in, that you can't process checks. You don't have to give availability under your normal schedule. It's this emergency condition. Now, the italics is verbatim. I need you to pick up your pens. It says emergency conditions. You may delay deposits other than cash, electronic deposits, and honest checks for a reasonable time. It's not even 7 days. The idea is that you're going to give a notice when you can. It says within a reasonable time. and you're going to tell them that funds will be available as soon as you can get them available. I mean, it's like there is no 5 days, 7 days, whatever. You don't have to give them the 225 that kicks in or this summer, things like that. You can hold for a reasonable time. You can give them the hold notice in a reasonable time. It's a little weird. There is some Reg CC training down there, but again, I hope that doesn't come into play. But it was something as we were brainstorming about what all is on the table here, this came up and it affects. So anyway, let's move on. Kevin, talk about social distancing and those. And Jared, I'm going to try to see if I can get some things fixed on this end. So I might black out a minute.
All right. Well, social distancing is, of course, the buzzword that we've all been hearing for weeks now, if not a little bit longer. And every bank is doing something a little bit differently. I know a lot of my clients, some of them are either restricting hours, or maybe they're closing facilities and trying to limit foot traffic in a variety of ways. And you may actually need to temporarily close facilities either for staffing or because of maybe the area that you're in is a higher risk and you're just trying to limit exposure. Now, the FDIC and the regulators have really asked that we do what we can to reduce any kind of disruptions to services that are out there, and where possible, provide alternative service options. So in other words, if you're going to close your branch down, really whenever practical, let your customers know how else can they maintain their services. Do you have, where are your ATMs at? Do you have an online option? Do you have, I know there's some video options that are being explored by a variety of banks. So if you have some alternative, communicate that to your customers. And then also reopen facilities whenever it's safe to do so. They also are encouraging that you notify your regulators if you're going to restrict some of the activity to the services, and just let them know. I get the sense that they're going to be as flexible as possible to allow you to continue your business, but do it as safely as possible. The FDIC also said that they're going to expedite any requests to, operate temporary facilities or things along those lines. So take a look at the FAQs that are out there. It's in your materials, and there's a little more detail there. But really, from a practical sense, you don't want to forget about these disclosures that are required to go out. For instance, for your deposit products, you're required to provide disclosures either before the account is opened or before the service is provided. And you may be changing fundamentally the way you typically open an account. So you might want to think through that process. Now, if the individual is not present, then you can drop it into the mail, and you no later than 10 days, and you can mail them out. If you want to provide them electronically, you need to make sure that you're following the e-Sign Act. And we'll get into that a little bit in a minute. But also remember that it's not just new customers, it's customers who come in and they ask for the disclosure. They ask for things about their information about their deposit accounts. Then you do have to provide it to them within a reasonable amount of time. So don't forget that if they're asking for this type of information, you are required to provide it. Loans, it's even more of an issue as far as I can tell. Jared's already covered, there's a lot of disruption, particularly in your mortgage loans, but really, you may have to remind people how that mailbox rule works. I know a lot of loan officers are used to just hand delivering their disclosures. So they don't really have to process everything. They complete their loan estimate and they hand deliver it. And that might not be an option for a lot of your loan officers anymore. So you may need to remind them how that works, that they have to drop it in the mail within 3 business days. And then also remind them that they can't just email it out unless you followed e-Sign. Now, I don't want to go too deep into e-Sign, but keep in mind there's the e-Sign disclosure that has to be provided. The individual or the customer has to consent to the electronic disclosure, but then also they have to consent in a manner that it's reasonably demonstrates that they can access the information. Now, if you have a program at your bank that's been vetted, go ahead and use it. It's a great option. But if you don't, watch out for loan officers who might decide, you know what, I'm in a rush here. I can't have them come in because our branch is closed, so I'm just going to send them an email. If you don't have an e-Sign compliant pathway to get that out, it's like that disclosure never happened. All right, and that's what I had on that. And And Dave, I don't know if you're back or not, but I can just jump right into the next one, the Fair Credit Reporting Act. If you look at the FAQ number 2, they also gave us a little guidance. Okay, so how are we to report delinquencies? And really, it was relatively simple the way they approached it. So if your borrower was current and then they're affected by the pandemic, and you work out some kind of payment accommodation with them, so they're having a disruption in their income stream, and you work something out with them. Now, if they were current at that point, the guidance is if they are following the rules of the payment accommodations you make, and they're consistent with the terms of that agreement, then you don't report them delinquent. Now, if they were past due at the time that they were affected by the virus or any of these shutdowns, then you would basically keep that delinquency status that they were at when they came in and asked for an accommodation, and just continue reporting that. So it's basically freezing them in time. So in other words, if somebody is 60 days past due, they come in and you provide them some kind of workout or an accommodation. And so then you would just report that they'd remain 60 days past due during that deferral period. Oh, not Dave, I'm still not hearing you. Let's see. No, silent. Well, let's see, where are we going next?
Well, let's do this. I'll jump in here while Dave's doing that. Here's what we want you to know. We've taken about 45 minutes here, hopefully to give you some awareness in this time of uncertainty as it relates to regulatory compliance matters. And we are a phone call away, and we are here to help you with those needs, whether it's a consultation over the phone, we've got webinars, we've got lots of different solutions that we have in place to help you all out. So in addition to helping you all, I want to mention, if you haven't checked them out, we have redesigned our training packages. You can check them out on our website. There's we basically slashed the price in half for our all-inclusive. And if you want to talk about that, we certainly can. We've got resources on our website. If you haven't been there before, there's lots of things that will aid you in your day-to-day compliance battles as it relates to these regulatory requirements. We've got about 13 minutes before the top of the hour. What I want to get to is your questions. Now I want to invite Diane Dean, my teammate, to come in. She's been moderating, and I see we have more than we'll be possibly able to get to. So let's get to those questions and try to find some solutions.
Okay, first off, any thoughts on HPML appraisals? People are saying that they're having a hard time getting appraisers to go into homes at this time.
And I tell you what, this is one I hadn't thought of. So I was listening to Dave and Kevin and reading some of these questions, and I went, I get it. So to bring you up to speed, just quick share, if you're making an HPML, there's a slew of appraisal requirements that go with it. Now, one of the ways you can get out of those appraisal requirements, all of them, is to make a qualified mortgage, and any variety of qualified mortgage will get you out of those appraisal requirements. But let's pretend you don't have a QM, and so you have to follow these strict appraisal requirements. Now, there's a lot of other exceptions too, but let's just pretend you have to go into that area. Well, one of the requirements is you have to get an appraisal, a new one, and it's got to be done by a certified and licensed appraiser, and it can't just be a drive-by. They have to make a physical, they have to get out of their car and physically inspect the property and go inside the property. I get it. There's a whole lot of people that are concerned about being around, social distancing, right? Kevin talked about it. It would take a rewrite of the regulation to not have to be able to do that. So my answer would be, you have to do that if you're making an HPML, and you can't find a way to make it be excluded under one of the many exemptions that exist for those appraisal requirements. There's no relaxation yet that we're aware of in that area, so they'll still have to do it. Now, you might find that you don't have an appraiser that's able to do that. That becomes a rock and a hard place, and I don't have much more for you there.
What are the recommendations to document loan modifications, skip payments, or other concessions that we're making for customers?
What I would, Kevin, do you want to take a stab? Go ahead.
Well, and I would say, that are they asking about documenting the file? I mean, really, I would tell the story. And in fact, it would, when in doubt, tell the story. I would sit down and outline, why is this happening? And then go in and find out, okay, can we get updated financials? Is this a situation where we can pull together their financial system or their financial situation and update that to show that we've done our underwriting? But really, I think you're going to run into so many unusual circumstances. And I think the traditional rules are getting a little loose right now. But I would say the important thing is to make sure that it's very clear when I pick up that file 6 months from now that I know exactly why this happened. Do you have anything to add, Jared?
Yeah, just what's the hardship and why did you do it? I think just tell that story, whether it's in the written file, the electronic file, somewhere documented.
If we defer a monthly home loan payment that includes escrow and we stretch that escrow payment out for 12 months and increase the monthly payment to cover it, would we need to do an escrow account statement?
Well, when it comes to escrow statements, just because you modified by deferring the payment doesn't mean you have to do anything with the escrow account. Now, if you reanalyze the escrow account and do something different to it today and run an analysis, then you'd provide a new statement. But if it's you're skipping a payment, but the escrow account stays the same, you wouldn't have to redo it. Once every 12 months is what's required.
Can we change the interest rate without it being a refinance?
Yeah. Yes. You can change it without being. You can go ahead and as long as your document clearly states how exactly you're doing it and doesn't conflict with something in the original agreement, you can do that. Yes.
Yeah. Up or down? That's because I see there's several of those questions. Up or down, doesn't matter. Modifications can be done to do that.
Okay, well, we have a few on waiting periods. If a customer needs to waive their waiting periods, is that considered a bona fide personal financial emergency?
Well, if I just came in and say, hey, Kevin, I need to waive my rescission period and TRID waiting period and HPML or I'm sorry, high costs, I just need to waive them. That's not a bona fide personal financial emergency in and of itself. It's got to be something like a hardship. The flood just came through, the tornado just went through town, funeral expenses, and I'm certain there will be because of the COVID-19, there's going to be circumstances that would lend themselves to bona fide personal financial emergencies. Let's go back to what Kevin talked about in answering the previous question. You've got to tell the story. Right. You, at the end of the day, the bank is the one responsible for justifying that bona fide personal financial emergency.
If they're just coming in and they want to invest, or they want to, invest in the stock market really quick because it's as low as it's going to go, and then that's not a bona fide personal financial emergency.
Yeah. But I'm out of money and I've lost my job. My spouse has lost their job, and we've got to buy groceries for the next month because this thing's. That could be.
Mm-hmm.
And along those lines, do we need to document the financial emergency or hardship?
Yes.
How about for high cost mortgages? Can you clarify whether we can waive that waiting period?
Yes, it can be waived. Bona fide personal financial emergency, what Dave talked about earlier in the program.
Okay, we have a couple of questions on Reg B, the Equal Credit Opportunity Act. Speaking of waiting periods, what about the ECOA appraisal delivery requirement? Do you think that could be waived?
You want to take a stab, Kevin, or?
Well, I think is that one you can waive. It's a little bit different than the HPML one, but you can waive that one.
Yeah, it's a little tricky. Mm-hmm. So Dave, Kevin, you mentioned something there. So we're talking about Reg B. That's the way the question is framed, and you are absolutely right. It can be waived. It's got to be done 3 days before closing. So you're going to have a 3-day time frame no matter what. And you don't get to waive it. The applicant gets to be the one that gets to waive it. So they'd have to say, I'd like to waive my right to get a free copy of the appraisal. Now, if you're not ordering appraisals, then you don't have to worry about the free copy, because that's really what this question is surrounding. So if you're not planning to order an appraisal, then or rely on an appraisal. Now, I'm not sure that's great underwriting or good safety and soundness, but then you wouldn't have to worry about that free copy. But if you rely on something, Kevin, if he's the customer, can waive it today, but we can't close until 3 days later. And then if it's an HPML, you can't waive it. It can't be waived at all. So there's definitely several intersecting factors there that we have to deal with.
You guys are doing great. Can you hear me?
Yeah, we can hear you, Dave.
Yeah.
Okay, can you see me?
Yes.
I actually called in on my cell phone. I have no idea. That's not important. You guys are doing awesome. Let's keep going. I just want to let you know I'm here.
All right.
So,
Okay. Do we still need joint intent on a 6-month extension?
let me take that one. Joint intent is technically required anytime you do anything different, anytime you have an application. And if you're going to do something different than what you originally applied for, then yes. So imagine my wife and I have a car loan, and then I've lost my job or the payment, and I come in and I say, hey, can we get an extension? Technically, Karen's on that loan too. And so you would need all parties to say, is this what you all want to do? I'm going to tell you, when it comes to 1 month, 2 months extension, stuff like that, I've never seen a regulator criticize that. And I've seen that where maybe on a commercial loan, they just can't make their payment until they sell a widget or grain or whatever. And so the bank does a month or two extension. Technically required. I've never seen it criticized. And again, I feel like there's going to be some grace in this area for that type of thing. So don't sweat that stuff, is what I want to say. I know that's a little rough, but go ahead, Kevin.
To add to it, Dave, I would say the one thing I would sweat is when you have, right now, you may have a lot of commercial loans where people are coming in and they're wanting modifications or extensions or additional funds, or, they're asking to change the deal. Be sure that your loan officers know to document who is applying for this loan at this point, because I've seen during times of strife, later on when the lawsuit comes out, you have people who were on the original loan say, you know what, I had no idea what was going on during that emergency. I didn't know I was going to be liable for that. And then you're fighting in court about it. Yeah. So I would just focus there a little bit.
Yeah, who am I talking to? Who are they representing is always something you should document. Yeah.
What about modifying a 1-year construction loan another year? Does that affect the ability to repay or HPML requirements?
I'll take that one. So if we're talking about consumer construction lending, most banks structure those at 12 months or less on purpose so that you can avoid having to deal with ability to repay requirements, which deal with the largest principal and interest balance or payment in like a 5-year time period. Well, that's always going to be the big old balloon at the end. So there's an exemption for 12 months or less. So if you're listening, maybe this is something you haven't heard before, but you should structure your construction loans at 12 months or less. It avoids ability to repay. If we do a modification and extend them, which is the way to go with these, by the way, you avoid ability to repay, and you can do it and handle it just like Dave talked about at the opening of the program.
Can we limit the amount of cash that a customer withdraws from their account? Such as, can we limit in-person cash withdrawals to $3,000 a day without violating any regulations?
Let me go first on that one. I don't know that there's any regulation. There are certainly some, I think, some state issues. I've heard some things. I don't know of any Reg A through Reg Z that affects that. And you're going to have a run on a bank if that word gets out that says the bank XYZ wouldn't let me have my money. Then they go tell everybody that at the coffee shop. Well, they may not because of social distancing, but they put it on Facebook. That's some dangerous ground to get into. Not really our area of expertise. I'm just going to, Kevin, Jared, Diane, do you guys get an opinion?
I've seen banks that have, when it's a large amount of cash, what they'll do, they'll have the depositor sign something acknowledging, cash it's very risky taking the cash. In fact, you might want to modify it and say, remind them there are all these scams out there related to the pandemic, and at least have them sign something, and it might make them rethink, really, do I need all of this cash? But it's not.
People are fearful right now, and it's really not our area of expertise to talk about that. I don't know of any restriction by regulation.
For a Reg CC delay, is it on the bank to prove an emergency circumstance and or the reasonable time?
Absolutely would be. But the reg is, so we've given you the citation there. You can go look at those things. It's not 1029. The CFPB doesn't own this. It's 229 still. You could go to your online regs, your books over 229.13 F4. There's also in G4 about the notice. Check those out. It's just whatever's reasonable under the circumstances. Now, what is that? It's in the eye of the beholder. So you could have an examiner later criticize you. I would be more concerned about the customer criticizing you in this case, saying what gives you that right. that to me is, we just can't process these checks or certain things. Don't use this just because you're doubting collectability. You use this because there's no personnel there to process the checks. And that's probably not today. That may come down the road. That's why I wanted to put that on the agenda. But yeah, I mean, the answer is yes, you're going to have to prove the reasonableness.
We send out our best effort closing disclosure, then provide an accurate disclosure later. Do we need to push back closing based on the day the accurate closing disclosure was sent?
Okay, there's a couple things going on with that question I want to deal with. I hope it's not your normal practice to send out our best guess, or how did you say that, Diane? Best
effort.
The best effort closing disclosure. I hope that's the exception and not the rule. So we'll just leave that aside. So in this time frame that we're living, you might have troubles getting things from third parties. If you follow the rules I gave you earlier, you can, based on the best information available, if today is Wednesday and you need to close next Wednesday and you're mailing a disclosure, based on that best information, you can send that closing disclosure out today. And then when you get accurate information, you'll provide a revised closing disclosure. Is there a 3-day waiting period tied to that revised disclosure? There could be. There's 3 different things that add a 3-day delay onto a revised disclosure. It's going to be a loan product change going from fixed to variable, a over or understated APR, which I don't have time to get into today. There's a whole lot behind that. And the third thing is adding a prepayment penalty. As long as you avoid those 3 things, that revised disclosure you give out because the first one wasn't accurate because you didn't have third parties that were playing nice with you, you won't have an additional 3-day waiting period in most cases.
Let me do this before we go on. It is an hour. We're going to stay on here. I mean, I see there's over 70 questions. So there's no way we're going to be able to get to all these. But we are going to put up a survey. We want you to know we're here to serve you. And absolutely, you are in our thoughts and our prayers. We want to help you through this time. These are unique times. It's not nothing we've ever seen, and you know that. So there's a survey that's going to pop up. If there's things that we haven't thought of, put some comments in there. If there's questions, things like that, email our office. We want to help you with this. We want to be able to here to serve you. So please let us know. Maybe we need to do another one of these. We've got all sorts of resources we've mentioned available. But let me soft close with that. If you need to run, that's the hour we promised, and maybe you've got to go to some other meeting. But we'll continue on here for 5-10 more minutes and answer as many questions as we can. So, Diane?
Okay, another potential trade issue related to appraisals. Appraisers are not giving quotes. We give an estimate based on the best information we have, but if it comes in higher later, can we pass that fee along even though it's a zero tolerance fee?
Kevin, you want to take a stab? Or?
Well, and really the question is, why is it coming in higher later? That's what I would really want to nail down. Was there, is it something that you didn't know? Like you have your standard appraisal that, normally the fees are pretty well within this range. And then it comes in higher. Well, was there something different about the appraisal? Was it, they went through, and a lot of times you'll see these re-inspection fees where they went out, there's, hole in the roof, and the appraiser said, okay, until that's fixed, I need to come back later when the hole's fixed, and I'll verify it's fixed, and I'm going to charge you extra for that. Well, that's something you didn't know about, so that's a valid change in circumstances. Now, if it's something like mileage, and you knew that this property was 100 miles away, and the appraiser they charged you mileage and you missed it, well, that's something you should have known at the time you made your estimate. So the question is really, it's tied in, but was there a change in circumstance that led it to go up higher? And I'm afraid that there may be changes in circumstances right now because appraisers are. I haven't seen it yet, but is there going to be a premium fee for going into a location now and doing an in the rather than a drive-by? Actually going into the property? I don't know, but there could be things that are changes in circumstances that you just don't know that they're gonna happen, and it could be related to this pandemic and the shortened supply. So the question is, really, it comes down to, what did you know when you made the estimate, and was there something new that caused that fee to change?
Can the borrower of a TRID loan request to skip a payment or two Can we do so without extending the loan's maturity date and by adding the skipped payments to the balloon without triggering new disclosures?
Let me tackle it from a TRID standpoint. I don't think TRID cares because TRID disclosures are at closing. Once you close, TRID is done. Now I'm going to go turn it over to Dave if you wouldn't mind coming and chiming in. As far as just tacking it onto the balloon, I still think that would take a modification, some sort of legal document to make that happen.
Yeah, yeah, and it purely is contractual. So you're going to add money to, something like that. Is that what you're saying?
Yeah.
Yeah, so again, joint intent might come into play, flood might come into play. It's not a HMDA, it's not a RESPA, it's not a truth in lending. We can add money. That's a little weird, but you can add money to an existing loan and technically not call it a refinance. All parties have to agree,
Yeah, if what they're asking is if Kevin calls me up and says, hey, I can't make the next 2 payments, and the loan officer just says, we'll just write them down and have you pay it with the balloon at the end. Well, that's not legally enforceable.
That'd be a modification.
Anything, and that's a bad practice.
No, that's a modification.
Right.
Yeah, you need to modify the loan, and yeah. And so you're not adding money. You're saying you're not extending. You're just re-amortizing, if you will. Yeah. Sorry.
For deferring payments that include escrow, how would you handle customer notification that there will be a potential shortage?
You technically don't have to do anything until you come to that annual analysis time. I think good customer service would be, hey, if you miss your April payment, you're going to be short when it comes to this, and so we'll spread it out. Basically, you're going to owe us 13 months of escrow over the next 12 months. So we get there, but it's not technically required until you get to the annual analysis. I think it'd be good customer service to give them a heads up. But when you do your next annual analysis, you're going to see that, we're probably short. And now we're going to have to make up that.
Regarding modifications and the inability to go from fixed to variable rate or closed to open end, does that apply to commercial loans as well, or only for those for consumer purpose?
Yeah, that's a truth in lending Reg Z requirement. So that means consumer only. Good clarification. I'm glad you brought that up. Everything that I talked about under RESPA, HMDA, well, it's not a HMDA, but because HMDA is also commercial loans, but RESPA and truth in lending, that's consumer driven. Very good point. And again, our article, I believe, addresses that.
Due to the recent decrease in interest rates, we have had several requests for modifications of the interest rate for commercial loans. Can we charge a fee, and can it be a flat modification fee or based on a % of the loan?
Yeah, I'll take that. You can charge anything you want. This is not regulatory mandated. So modifications, extensions, all those things where you're not having to give new disclosures, there are no federal rules about it. I know lots of banks that do at Christmas time a skip a payment and they charge $50 or $35 or $100 or whatever. That's a customer service issue. It's a management issue. You decide what you think is appropriate, and it's just has to be disclosed. It's contractual. It's not regulatory.
That's one of those where I'd make sure I find some common, consistent ground. I mean, you could
Yes.
You could do some different things there with higher dollar amount loans, especially on the commercial side, but don't just have lenders making their own thing up there.
Sure. Yeah. Maybe it is a percentage. Maybe it is a flat fee, and then if it's over that, but that's something management probably should decide, correct, and be consistent. Yeah.
Does a skip payment plan require a new flood determination on a property that is in a special flood hazard area? Or if the determination is less than 7 years old, can we rely on the one in the file?
All right. So there's a couple things here. So does a skip a payment trigger flood? Only if you're increasing the loan amount or extending the maturity date. If you're skipping a payment and adding that payment to the balloon or the end, no, you didn't touch the loan amount, you didn't touch the maturity date. If you make a 36-month loan become a 37-month loan, that's an extension. Then you would. So now we have to do all the flood rules. Can you rely upon a previous termination? Yes, if it's within 7 years, the map is still exactly the same map and nothing's changed there. It's on a flood determination form. Those are the 3 criteria that are required to rely upon a previous determination. Did I get it all, Diane? There was quite a bit in that question.
I believe so. Yep.
I think so. Jared's giving me a thumbs up. Okay.
On servicing, do you recommend that we continue making phone calls and sending delinquency notices? It almost seems contradictory to what we're hearing about servicers being encouraged to work with borrowers.
Well, as far as the delinquency notice goes, like your 30-day past due, that's not a regulatory compliance thing. So let's set that aside. The servicing rule that is early intervention, you've got to follow that if you're a large servicer. So if you're a small servicer, I suppose it's up to you. But if you're a large servicer, before day 36, you've got to demonstrate that you're making live contact and providing options. I don't think that flies in the face of what's going on. You're simply trying to reach out with a helping hand and saying, you might be struggling. How can we help? Here's some options. So I don't see that as flying in the face of what's being said. I see that as being proactive and while doing so, following the rules that are in place.
Let me do this. We've got, hang on, Dan. We've got more questions than we'll ever be able to get to. We certainly want to help. How about one more, Diane? And then we're going to cut it off here.
If institutions are denying deferrals, are they sending adverse actions?
Yeah, I'm going to take that. If someone comes in and requests some type of deferral, extension, whatever, that is a request for credit. And if you say, sorry, we can't help you, you owe them an adverse action notice, a denial notice. So that is true. So Jared, you got something you want to add to that?
We need to add on to that. There is some very strict red tape in the servicing rules. If we're talking about a home loan that's consumer purpose secured by the borrower's primary residence, you can't just straight up turn them down. In fact, under loss mitigation rules, you have to evaluate them for all the options that are available, not just what they ask for. And then if you do say no to all available options, they have 14 days to appeal it. So there's a whole lot of moving parts there in loss mitigation.
So let me do this. What I was talking about is car loans, commercial loans, non-home loans that are subject to the servicing rules, right? When it gets to the servicing, man, like you said earlier, there's a ton of things in the weeds there. So let me cut it off there. Again, we want to let you know that you are in our thoughts and prayers, and we want to serve you. So hopefully this has been beneficial. It is being recorded. We will put the recording out. We won't be providing written answers to all these questions, but we will provide the video. That'll be in your products. We'll have it in your store. You'll be able to download that here in a little bit. We'll send you a notification. So call us, let us know how we can help if you have questions. I know there's lots more that we didn't get to. My apologies for the audio technical issues that I'm assessing right here, but I appreciate the team. So thank you to our team. We want you to let you know we're here to help. And so we appreciate you, and good luck through this difficult time. We'll be in touch. So thank you. Thanks, team.